Greetings and salutations, this is Huge Ass! When Flers are desperate to prove that Antarctica isn't a real place, that it's just an ice wall, they cite what they call the Antarctic Treaty, and they say it bans people from going there. I thought, let's put this to bed once and for all. This might be a relatively boring video, but I think it needs to be done. I'm going to read through the Antarctic Treaty. So the next time you hear a flurf saying that you can't go to Antarctica because the Antarctic Treaty prevents you, point them to this video. You might treat this as an audiobook if you wanted to learn about the Antarctic Treaty. It's easy to access. It's online. It has its own website, ats.aq, AQ for Antarctica. Just click More under the very first paragraph that you see. Scroll down, and down the bottom you'll see Antarctic Treaty. Click on that, and the PDF will download. Open up the PDF, and this is what you have. As you can see, it was published December 1st, 1959. The Antarctic Treaty, and in various languages. The governments of Argentina, Australia, Belgium, Chile, the French Republic, Japan, New Zealand, Norway, the Union of South Africa, the Union of Soviet Socialist Republics, the United Kingdom of Great Britain and Northern Ireland, and the United States of America, recognising that it is in the interest of all mankind that Antarctica shall continue forever to be used exclusively for peaceful purposes and shall not become the scene or object of international discord. Acknowledging the substantial contributions to scientific knowledge resulting from international cooperation in scientific investigation in Antarctica, convinced that the establishment of a firm foundation for the continuation and development of such cooperation on the basis of freedom of scientific investigation in Antarctica as applied during the International Geophysical Year accords with the interests of science and the progress of all mankind. Convinced also that a treaty ensuring the use of Antarctica for peaceful purposes only and the continuance of international harmony in Antarctica will further the purposes and principles embodied in the Charter of the United Nations, have agreed as follows. God, they don't like commas, do they? Article 1. Antarctica shall be used for peaceful purposes only. There shall be prohibited, inter alia, any measures of military nature, such as the establishment of military bases and fortifications, the carrying out of military manoeuvres, as well as the testing of any type of weapons. The present treaty shall... Point 2. The present treaty shall not prevent the use of military personnel or equipment for scientific research or for any other peaceful purpose. So you can't have a military base in Antarctica. So if, as the flurfs say, the military are protecting people from, well, stopping people from going to Antarctica, where are they based? It's too far away from any other land to be properly resupplied. Anyway, Article 2. Freedom of scientific investigation in Antarctica and cooperation toward that end, as applied during the International Geophysical Year, which was 1957, shall continue, subject to the provisions of the present treaty. Article 3. In order to promote international cooperation and scientific investigation in Antarctica as provided for in Article 2 of the present treaty, the contracting parties agree that, to the greatest extent feasible and practical, information regarding plans for scientific programs in Antarctica shall be exchanged to permit maximum economy and efficiency of operations. B. Scientific personnel shall be exchanged in Antarctica between expeditions and stations. C. Scientific observations and results from Antarctica shall be exchanged and made freely available. So what they're doing down there, they're not hiding from each other. And remember, the US and the Russians were signatories to this, so they had to share with each other. Point 2 of Article 3. In implementing this article, every encouragement shall be given to the establishment of cooperative working relations with those specialised agencies of the United Nations and other international organisations having a scientific or technical interest in Antarctica. So in other words, work with the UN. Article 4. Point 1. Nothing contained in the present treaty shall be interpreted as a renunciation by any contracting party of previously asserted rights or of claims to territorial sovereignty in Antarctica. Point B. A renunciation or diminution by any contracting party of any basis of claim to territorial sovereignty in Antarctica, which it may have, whether as a result of its activities or those of its nationals in Antarctica or otherwise. C. Prejudicing the position of any contracting party as regards to its recognition or non-recognition of any other state's right or of or claim or basis of claim to territorial sovereignty in Antarctica. Point 2 of Article 4. No acts or activities taking place while the present treaty is in force shall constitute a basis for asserting, supporting or denying a claim to territorial sovereignty in Antarctica or create any rights of sovereignty in Antarctica. No new claim or enlargement of an existing claim to territorial sovereignty in Antarctica shall be asserted while the present treaty is in force. Article 5. Any nuclear explosions in Antarctica and disposal there of radioactive waste material shall be prohibited. Article 5.2. In the event of the conclusion of international agreements concerning the use of nuclear energy, including nuclear explosions and disposal of radioactive waste material, to which all of the contracting parties whose representatives are entitled to participate in the meetings provided for under Article 9 are parties. The rules established under such agreements shall apply in Antarctica. Article 6. The provisions of the present treaty shall apply to the area south of 60 degrees south latitude, including all ice shelves, but nothing in the present treaty shall prejudice or in any way affect the rights or the exercise of the rights of any state under international law with regard to the high seas within that area. Now, that's probably the first thing that's come close to saying that people aren't allowed to go there, but it's only sort of like very obliquely. So it won't affect the rights of any state under international law regard to the high sea. So it's more about fishing than anything else. Article 7. In order to promote the objectives and ensure the observance of the provisions of the present treaty, each contracting party whose representatives are entitled to participate in the meetings referred to in Article 9 of the treaty shall have the right to designate observers to carry out any inspection provided for by the present article. Observers shall be nationals of the contracting parties which designate them. The names of observers shall be communicated to every other contracting party having the right to designate observers, and like notice shall be given of the termination of their appointment. Point 2 of Article 7. Each observer designated in accordance with the provisions of paragraph 1 of this article shall have the complete freedom of access at any time to any or all areas of Antarctica. So that particular point means that there is nowhere in Antarctica that the other guys can't visit as well. So the Russians can check on the US and the US can check on the Russians and whoever else. Point 3 of Article 7. All areas of Antarctica, including all stations, installations and equipment within those areas, and all ships and aircraft at points of discharging or embarking cargoes or personnel in Antarctica, shall be open at all times to inspection by any observers designated in accordance with paragraph 1 of this article. Point 4. Aerial observation may be carried out at any time over any or all areas of Antarctica by any of the contracting parties having the right to designate observers. Article 5. Each contracting party shall, at the time when the present treaty enters into force for it, inform the other contracting parties, and thereafter shall give them notice in advance of A. All expeditions to and within Antarctica on the part of its ships or nationals, and all expeditions to Antarctica organised in or proceeding from its territory. So in other words, they've just got to let each other know what's going on. So this is about the actual governments. This isn't about individuals. All stations in Antarctica are occupied by its nationals. So, if you've got a station down there, you've got to let everyone else know that you've got one down there. And Section C of Point 5 of Article 7, any military personnel or equipment intended to be introduced by it into Antarctica subject to the conditions prescribed in paragraph 2 of Article 1 of the present treaty. In other words, if you're going to move anything military down there, you've got to let everyone else know. Seems reasonable. Article 8.1. In order to facilitate the exercise of their functions under the present treaty, and without prejudice to the respective positions of the contracting parties relating to the jurisdiction over all other persons in Antarctica, observers designated under paragraph 1 of Article 7, and scientific personnel exchange under subparagraph 1b of Article 3 of the treaty, and members of the staffs accompanying any such persons, shall be subject only to the jurisdiction of the contracting party of which they are nationals, in respect of all acts or omissions occurring while they are in Antarctica for the purpose of exercising their functions. So that's pretty clear. That's basically, if you're in the Australian Antarctic area, for example, Australian Antarctic Territory, that's what it's called, you're subject to Australian law. If you're in the Norwegian part or the Russian part or the New Zealand part, you're subjected to the law of those nations. Point 2. Without prejudice to the provisions of paragraph 1 of this article, and pending the adoption of measures in pursuance of subparagraph 1e of Article 9, the contracting parties concerned in any case of dispute with regard to the exercise of jurisdiction in Antarctica shall immediately consult together with a view to reaching a mutually acceptable solution. In other words, work together. Article 9. We've heard this a few times, so let's see what it says. Section 1. Representatives of the contracting parties named in the preamble to the present treaty shall meet at the city of Canberra within 2 months after the date of entry into force of the treaty, and thereafter at suitable intervals and places for the purpose of exchanging information, consulting together on matters of common interest pertaining to Antarctica, and formulating and considering and recommending to their governments measures in the furtherance of the principles and objectives of the treaty, including measures regarding a. Use of Antarctica for peaceful purposes only. B. Facilitation of scientific research in Antarctica. C. Facilitation of international scientific cooperation in Antarctica. D. Facilitation of the exercise of the rights of inspection provided for in Article 7 of the treaty. E. Questions relating to the exercise of jurisdiction in Antarctica. F. Preservation and conservation of living resources in Antarctica. Section 2 of Article 9. Each contracting party which has become a party to the present treaty by accession under Article 8 shall be entitled to appoint representatives to participate in the meetings referred to in paragraph 1 of the present article, during such time as that contracting party demonstrates its interest in Antarctica by conducting substantial scientific research activity there, such as the establishment of a scientific station or the dispatch of a scientific expedition. Section 3, Article 9. Reports on the observers referred to in Article 7 of the present treaty shall be transmitted to the representatives of the contracting parties participating in the meetings referred to in paragraph 1 of the present article. Section 4, Article 9. The measures referred to in paragraph 1, I guess I should be calling them paragraphs. So paragraph 4 of Article 9. The measures referred to in paragraph 1 of this article shall become effective when approved by all the contracting parties whose representatives were entitled to participate in the meetings held to consider those measures. Paragraph 5. Any or all of the rights established in the present treaty may be exercised as from the date of entry into force of the treaty, whether or not any measures facilitating the exercise of such rights have been proposed, considered, or approved as provided in this article. Article 10. Each of the contracting parties undertakes to exert appropriate efforts consistent with the Charter of the United Nations to the end that no one engages in any activity in Antarctica contrary to the principles or purposes of the present treaty. Article 11, Paragraph 1. If any dispute arises between two or more of the contracting parties concerning the interpretation or application of the present treaty, those contracting parties shall consult amongst themselves with a view to having the dispute resolved by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, or other peaceful means of their own choice. Paragraph 2 of Article 11. Any dispute of this character not so resolved shall, with the consent, in each case of all parties to the dispute, be referred to the International Court of Justice for settlement. But failure to reach agreement on reference to the International Court shall not absolve parties to the dispute from the responsibility of continuing to seek to resolve it by any of the various peaceful means referred to in paragraph 1 of this article. Article 12. Paragraph 1a. The present treaty may be modified or amended at any time by unanimous agreement of the contracting parties, yeah, that's going to happen, whose representatives are entitled to participate in the meetings provided for under Article 9. Any such modification or amendment shall enter into force when the depository government has received notice from all such contracting parties that they have ratified it. Section B of paragraph 1 of Article 12. Such modification or amendment shall thereafter enter into force as to any other contracting party when notice of ratification by it has been received by the depository government. Any such contracting party from which no notice of ratification is received within a period of 2 years from the date of entry into force of the modification or amendment in accordance with the provisions of subparagraph 1a of this article shall be deemed to have withdrawn from the present treaty on the date of the expiration of such period. Paragraph 2, Section A. of Article 12, if after the expiration of 30 years from the date of entry into force of the present treaty, any of the contracting parties whose representatives are entitled to participate in the meetings provided for under Article 9, so request by communication addressed to the depository government, a conference of all the contracting parties shall be held as soon as practical to review the operation of the treaty. Subsection B of paragraph 2. Any modification or amendment to the present treaty which is approved at such a conference by a majority of the contracting parties they represented, including a majority of those whose representatives are entitled to participate in the meetings provided for under Article 9, shall be communicated by the depository government to all the contracting parties immediately after the termination of the conference, and shall enter into force in accordance with the provisions of paragraph 1 of the present article, which is Article 12. Section C of paragraph 2 of Article 12. If any such modification or amendment has not entered into force in accordance with the provisions of subparagraph 1A of this article within the period of 2 years after the date of its communication to all the contracting parties, any contracting party may at any time after the expiration of that period give notice to the depository government of its withdrawal from the present treaty, and such withdrawal shall take effect 2 years after the receipt of the notice by the depository government. So all this is just sort of basic admin, how they work with each other and how they resolve disputes and that sort of thing. Article 13. Paragraph 1. The present treaty shall be subject to ratification by the signatory states. It shall be open for accession by any state which is a member of the United Nations, or by any other state which may be invited to accede to the treaty with the consent of all the contracting parties whose representatives are entitled to participate in the meetings provided for under Article 9 of the treaty. Paragraph 2. Ratification of or accession to the present treaty shall be effected by each state in accordance with its constitutional processes. Paragraph 3. Instruments of ratification and instruments of accession shall be deposited with the government of the United States of America, hereby designated as the depository government. Interesting. Paragraph 4. The depository government shall inform all signatory and acceding states of the date of each deposit of an instrument of ratification or accession, and the date of entry into force of the treaty and of any modification or amendment thereto. Paragraph 5. Upon the deposit of instruments of ratification by all the signatory states, the present treaty shall enter into force for those states and for states which have deposited instruments of accession. Thereafter, the treaty shall enter into force for any acceding state upon the deposit of its instrument of accession. Paragraph 6 of Article 13. The present treaty shall be registered by the depository government pursuant to Article 102 of the Charter of the United Nations. In other words, it's all backed up by the United Nations. And Article 14, which is the last article, the present treaty, done in English, French, Russian and Spanish languages, each version being equally authentic, shall be deposited in the archives of the Government of the United States of America, which shall transmit duly certified copies thereof to governments of the signatory and acceding states. And that's it. That's the entire Antarctic Treaty, in English anyway. I didn't see anything in there that says you are not allowed to go to Antarctica. Nothing whatsoever. The closest thing that comes is that in each of the relevant territories, the law of that country that claims that territory will apply. And if that government has some sort of law preventing you from going there, well, take it up with that government. But there's no UN law that says you can't go there, that's for sure. And nothing in this treaty says you can't go there. It'll be the individual governments that might stop you from going there. But in most cases, that's simply so that they know where you are, and if you get into trouble, they know to have resources on standby to help you out, which you'll have to pay for, of course, because unless you've provided evidence that you've got your own means of rescue. Because it's a pretty harsh environment down in Antarctica. Lots of people have died there. So the whole purpose of this is to go through and see if there is anything there that says that you can't go to Antarctica. And of course, there isn't. What that tells me is that the Flurfs haven't read it at all. The Flurfs are wrong. What a surprise. The corgi's warming up, so please click subscribe if you haven't already and give this video a like. It all helps the channel grow. So there's nothing left to do but cue the corgi.